The clerk will read the order of the day.
Government Business Notice Number 2, standing in the name of Ms Boothby to present the Defamation Legislation Amendment Bill 2025, Serial 13.
Minister.
Madam Speaker, I present a bill titled Defamation Legislation Amendment Bill 2025, Serial 13, and table the explanatory statement. Madam Speaker, the purpose of this bill is to amend the Defamation Act 2006 and the Limitation Act 1981 to fulfil the Northern Territory's commitment to implement nationally agreed reforms to the laws of defamation based on the model laws developed at a national level. The bill also makes an amendment to Section 131A of the Local Court Criminal Procedure Act 1928 to include the offence of unlawful publication of defamatory matter at Section 204 in the Criminal Code in the list of assault and harm offences that may be dealt with summarily. This will allow that offence to be dealt with in the local court rather than requiring a Supreme Court trial. This amendment is unrelated to the model laws but is otherwise related to defamation. The Defamation Act 2006 was introduced almost 20 years ago, implementing the model defamation provisions, upholding the Northern Territory's commitment to uniform defamation laws across Australia. Defamation is a cross-jurisdictional issue, as it is common for the same matter to be published in multiple jurisdictions. This makes achieving and maintaining uniformity in defamation law across Australia essential for reducing the potential for forum shopping, where parties might otherwise choose jurisdictions based on the perceived advantages of their laws for their claims or defences, and removing the need to navigate varying defamation laws across states and territories. Consistency in the defamation laws help ensure a fair and predictable legal environment, preventing disparities in the handling of defamation cases across different regions. Since the introduction of the model defamation provisions in each state and territory, the rapid development of the digital age has broadened the media landscape, with ordinary individuals now able to publish content widely via social media. A 2018 report by the University of Technology, Sydney, highlighted that defamation cases involving digital publications had surged, reflecting the broader shift towards online platforms. This raised the need for a review of the defamation laws to consider their continued suitability in achieving its aims of promoting speedy and non-litigious methods of dispute resolution and striking an appropriate balance between protecting freedom of expression, in particular for matters of public interest, while still ensuring the protection of a person's reputation from harm using effective and fair remedies. A review of defamation laws was undertaken in 2 stages, and amendments proposed to address issues identified with the model laws. Stage 1 recommended amendments which centred around issues of modernisation of the defamation laws to adapt to increasing prevalence of digital communications, the increasing use of defamation law for trivial matters such as neighbour disputes, insufficient incentives to engage in non-litigious dispute resolution, protection of publications regarding matters of public interest and education, and ensuring the current provisions were operating as originally intended. Stage 2 recommended amendments which gave further consideration to the liability of the digital intermediaries, such as internet service providers and social media platforms, when third parties use their services to publish defamatory content, and extension of the defence of absolute privilege to defamatory statements made to Australian police and other complaint handling bodies. Both stages involved an extensive review process with multiple rounds of public consultation, stakeholder roundtables, the engagement of expert panels, and the development of discussion papers and exposure drafts at a national level. Madam Speaker, the bill I introduced today reflects the Stage 1 and Stage 2 recommended amendments. Some of the more key amendments provided in the bill include the introduction of a serious harm element, changes to pre-litigation processes, new defences relating to public interest and peer-reviewed material published in academic or scientific journals, clarification of awards for non-economic loss, the introduction of a single publication rule, conditional exemption from defamation liability for conduit, caching and storage services, and for search engines in relation to organic search results. Requirement for courts to consider balancing factors when making preliminary discovery orders against digital intermediaries. A new innocent dissemination defence for digital intermediaries. A specific power for courts to make non-party orders against digital intermediaries to prevent access to defamatory matter online, and the extension of the defence of absolute privilege to matters published to police along with guiding principles. Overall, this bill is a critical step towards maintaining uniformity, refining and modernising Australian defamation law, and ensures its continued relevance and effectiveness. I now turn to the key provisions of the bill. A significant change to the defamation laws is the introduction of a serious harm threshold as a new element of the cause of action. This reform, detailed in the proposed new Section 9A of the Defamation Act 2006, requires plaintiffs to prove that the publication of defamatory material has caused or is likely to cause serious harm to their reputation. For corporations, the threshold includes demonstrating serious financial loss. By imposing this threshold, the bill aims to filter out trivial, minor or frivolous defamation claims early in the litigation process. This change is intended to reduce the burden on courts, limit unwarranted legal costs for businesses and individuals, and promote early resolution of disputes. The defence of triviality, which involves establishing that the plaintiff was unlikely to suffer harm, will be repealed, as this serious harm threshold will render it unnecessary. The bill also introduces several key reforms to the pre-litigation process in defamation cases to encourage early resolution and reduce the burden on courts. The new provisions will make it mandatory for an aggrieved person to issue a written concerns notice dealing the specifics of the complaint and serve a waiting period before commencing court action. If the initial concern notice is insufficient, the publisher can request further details. This requirement aims to provide the publisher with enough information to make a reasonable offer, encourage meaningful negotiation and settlement before formal court action is commenced, and to ensure that the plaintiff has considered the serious harm threshold before proceeding. The bill also proposes several refinements to the offer to make amends procedure, including that the offer be made as soon as reasonably practicable after receiving the concerns notice, with the offer remaining open for at least 28 days. The offers to make amends have also been broadened beyond an offer to publish a reasonable correction of the defamatory matter to include an order to publish a clarification or additional information about the matter, accommodating situations where a factual correction is not applicable but additional context or information is necessary. An offer to include an apology or remove the defamatory material from a website can also be included. The defence for reasonable offers may also be relied on if the publisher remains willing to comply with the offer during the trial. For digital publications, an offer to make amends may also include an offer to take access prevention steps, for example, removing, blocking or disabling access, instead of or in addition to the other available offers, such as posting a clarification or correction, which may not be possible, such as for search engine providers. These refinements aim to encourage quicker, early and non-litigious resolution of defamation disputes, streamline and modernise the process of making and responding to offers to make amends, and reduce the burden on the court system. By enhancing clarity and providing more structured procedures, the bill seeks to make the process more efficient and equitable for all parties involved. The bill provides an additional significant shift in defamation law via the introduction and amendments of a number of defences. Current Section 27 of the Defamation Act 2006 provides a defence of qualified privilege where there is a legal or moral duty to make potentially defamatory statements. However, this defence has been critiqued for not adequately covering broader media publications, as it is challenging to prove a general public interest in the information. The new public interest defence addresses this critique by introducing a new section, 26A, to protect journalists and media organisations publishing matters of public interest in order to ensure the protection of freedoms of expression and public debate on matters of significant public concern. The defence requires the defendant to prove the statement was on a matter of public interest and that they reasonably believe the publication was in the public interest at the time. A non-exhaustive list of factors is also outlined for consideration by the courts. These factors are not intended to form a mandatory checklist, but rather may be used by the courts in evaluating the circumstances of each case. The defence of qualified privilege is retained, but amended to reduce overlap with the new public interest defence by removing or altering factors more relevant to the new defence. These changes are designed to better reflect contemporary media practices and ensure that defamation laws do not unduly inhibit important public discourse. The new defence of peer-reviewed scientific and academic journal publications is introduced in the new Section 27A of the Defamation Act 2006. The defence applies to defamatory statements related to scientific or academic issues published in a journal that has undergone peer review by an independent expert or editor, and extends to fair reports of the peer-reviewed statements and any assessments of these statements within the same journal. The peer review must be conducted by someone with expertise in the relevant scientific or academic field. However, the defence can be defeated if the plaintiff proves that the statement or assessment was not published honestly for the public's information or advancement of education. Existing defences, such as Section 26, provide some protection for academic and scientific publications, particularly those that are fair reports of public proceedings or relate to public concern. However, these existing defences may not fully address the nuances of academic peer review. The new Section 27A aims to offer clearer and more robust protection for peer-reviewed publications, recognising their role in advancing knowledge and scholarly debate. This is crucial for the advancement of knowledge and the integrity of scholarly communication. Various other defences have also been amended, such as the defence of contextual truth under the current Section 23 of the Defamation Act 2006, which allows the defendant to argue that the substantial truth of the contextual imputations in a publication renders specific defamatory imputations less harmful. The bill revises Section 23 to clarify that defendants can plead back imputations raised by the plaintiff. This change ensures that defendants can fully present the context of the statements in question. Section 28, the defence of honest opinion, currently provides a defence for expressions of opinion that are based on proper material and are in the public interest. The requirement for the opinion to be based on proper material and for that material to be set out clearly has faced criticism for being outdated, especially in the context of digital communications. The bill proposes amendments to update how proper material should be presented, including being set out either in specific terms within the publication or in general terms that are accessible. Proper material can also be notorious or widely known, or accessible through references, links, or other access points included in the publication, for example, hyperlinks or web pages. The proper material must be apparent from the context of the publication, making it easier for readers to understand the basis of the opinion. The defence of innocent dissemination under Section 29 of the Defamation Act 2006 provides a defence to subordinate distributors who can prove they neither knew nor ought reasonably to have known the matter was defamatory, and their lack of knowledge was not due to negligence on their part. For digital intermediaries, including forum administrators, issues arise in relation to this defence as it currently applies, where online platforms are monitored and unlawful content removed. There is a lack of clarity regarding whether having this ability to exercise editorial control means the digital intermediary could be considered an originator of the content. The requirement to prove a lack of knowledge of the defamatory content may also discourage digital intermediaries from monitoring these platforms in order to avoid knowledge of defamatory publications. To address these issues, new Section 28A provides a defence for publications involving digital intermediaries, such as social media platforms and forum administrators, where they have an accessible complaints mechanism which the plaintiff has used to provide a written complaint, and the digital intermediary has taken reasonable access prevention steps within 7 days of the complaint being made to remove, block or disable to the content. However, the defence does not apply if the digital intermediary was motivated by malice in providing the online service. By requiring a complaints mechanism and timely action, the defence encourages digital intermediaries to adopt and maintain procedures for handling defamatory content. It also acknowledges that not all digital intermediaries have the same level of control or ability to act on complaints, ensuring that those who act responsibly are protected from undue liability. A key reform is the extension of the absolute privilege defence to matters published to police, which is intended to encourage the report of serious offences and alleviate the concerns that reporting could lead to defamation claims. Section 24 of the Defamation Act 2006 provides a defence of absolute privilege, which is a complete immunity for matter published in proceedings of a parliamentary body or an Australian court or tribunal. Section 27 also provides a defence of qualified privilege, which could be used to protect reports to police and other complaint handling bodies. Currently, this defence would need to be established by the defendant and would be defeated if the plaintiff proves the publication was actuated by malice. But this would mean in cases where a victim survivor has made a report to police, the defendant could make a claim for defamation and assert they were lying, constituting malice, potentially deterring victim survivors from reporting serious offences. The bill proposes to extend the defence of absolute privilege to protect any communications made to an official of state, territory or Commonwealth police forces or services at all levels, including informal reports, emails and online submissions. This recognises that there are certain communications which are deemed to be more important than a plaintiff's right to protect their reputation by providing absolute immunity from defamation claims for statements made to police. The reform also seeks to remove barriers that might deter victims from reporting crimes. This is especially relevant for sensitive matters such as sexual violence, where fear of legal repercussions can inhibit reporting. Additionally, accountability for false statements is not diminished, as it remains an offence to provide false information to the police, ensuring that the reform does not shield malicious reporting. This reform is a significant step towards improving access to justice for individuals reporting crimes, particularly in sensitive areas such as sexual violence and harassment, and aligns with ongoing efforts to ensure that defamation laws do not act as a barrier to reporting serious criminal conduct. The effectiveness of these new defences will likely be assessed over time through judicial interpretation and application in various cases, ensuring that they're adequately balanced public interest and individual rights. The proposed amendments to Section 32 of the Defamation Act 2006 are designed to address several key issues related to the cap on damages for non-economic loss in defamation proceedings. This cap is adjusted annually and is intended to ensure proportional compensation while avoiding excessive awards. Under the existing law, courts may award aggravated damages for particularly harmful conduct, in addition to the capped amount for non-economic loss. However, there has been confusion and inconsistency in how these awards are applied. Recent cases have interpreted Section 32 in ways that deviate from its intended purpose. Some courts have allowed aggravated damages to effectively exceed the cap on non-economic loss, contrary to the original intent of the legislation. The bill amends Section 32 to clarify that the cap should be interpreted as a scale or range of damages for non-economic loss. The maximum amount represents the highest end of this scale, meant to apply only in the most serious cases of defamation. The bill stipulates that awards for aggravated damages must be made separately from the damages for non-economic loss. This ensures that the cap on non-economic damages remains intact even if aggravated damages are warranted. In order to prevent attempts to circumvent this cap, the bill also introduces restrictions on the filing of multiple lawsuits by requiring plaintiffs to seek court approval to bring further proceedings against the same or associated defendants regarding the same publication. These amendments will uphold the original intent of the cap and provide a more predictable and consistent framework for damages benefiting both plaintiffs and defendants, and ensuring the damages are proportionate to the harm suffered. The restrictions on multiple proceedings will also help streamline litigation and prevent abuse of the legal process by promoting more efficient and fair handling of defamation claims. The introduction of the single publication rule represents a significant update to address the challenges posed by digital media. The single publication rule aims to address issues with the multiple publication rule that currently applies to the defamation cases. Under the multiple publication rule, every download or access of a defamatory online publication is treated as a new instance of publication, potentially extending the limitation period indefinitely. The single publication rule specifies that the 1-year limitation period for defamation actions starts from the date of the first publication and does not reset with subsequent access or downloads. If a subsequent publication is materially different from the first, the limitation period may start anew. This includes changes in the manner of the publication, such as different platform or substantial modification of content. The court can also extend the limitation period up to 3 years from the first publication date if the plaintiff can demonstrate that it is just and reasonable under the circumstances. This provides flexibility for cases where the plaintiff may not have been aware of the defamatory material immediately. The bill responds to concerning about the multiple publication rule, creating unfairly extended limitation periods and of evidentiary difficulties for publishers. The single publication rule aims to balance the interests of plaintiffs and defendants while reflecting modern digital realities. In summary, the introduction of the single publication rule and related amendments aims to modernise defamation law by addressing issues specific to digital media, providing clearer and fairer limitation periods, and enhancing the efficiency of the dispute resolution process. Clause 33 of the bill introduces conditional statutory exemptions from defamation liability for certain digital intermediaries to reflect their passive role in content publication. Some digital intermediaries, such as caching services, conduit services and storage services, do not actively contribute to the publication of defamatory matter, and so the bill proposes to provide a protection to such services, regardless of whether they knew or ought to reasonably have known the digital matter was defamatory. This reform does not substantially change that law. These digital intermediaries are generally not the subject of defamation claims and are unlikely to be considered publishers under the common law test. The intention here is to provide clarity and certainty. The exception also only applies very narrowly with specific conditions that must be met to ensure this exemption does not apply if any of these services actively participate in the publication of defamatory content. A further conditional exemption is provided for search engine providers in relation to organic search results. This recognises that search engine providers operate via an automated process providing access to third-party content. They have no interest in the content itself or any relationship with author, and are unable to remove the content, only block it. The exemption applies to search results and hyperlinks generated by automated processes, not to sponsor results or content actively managed by the search engine provider. The exemption also does not cover autocomplete suggestions or AI-generated responses. The bill establishes a process for courts to determine whether these exemptions apply before a trial begins, aiming to reduce unnecessary legal costs and delays. These reforms are intended to clarify the role of digital intermediaries and ensure they are not unjustly held liable for third-party content while maintaining the integrity of defamation law in a digital context. When bringing defamation proceedings, a plaintiff is required to identify the author. This is difficult where people post online anonymously. Currently, a court can issue a preliminary discovery order to help identify an anonymous poster and may take into action a number of factors, including the proportionality, privacy and the risk of abuse of process in exercising this discretion. However, concerns have been raised regarding how this process may be abused, for example, against domestic violence victims or other vulnerable members of society. Therefore, the bill makes it mandatory for a court to consider the objectives of the Defamation Act, including providing fair and effective remedies and promoting speedy, non-litigious resolution, and any privacy, safety and other public interest concerns that might arise from the order. This change aims to ensure that courts balance the need to identify individuals for legal proceedings with protecting privacy and preventing potential abuse of the process. It seeks to promote consistency across jurisdictions and protect vulnerable individuals, such as victims of domestic violence. The requirement to consider these factors is intended to enhance the fairness and effectiveness of the preliminary discovery process without creating new avenues for such orders. The bill introduces a further significant amendment to the Defamation Act, granting courts the power to make orders against non-party digital intermediaries. The provision aims to enhance the enforcement of defamation judgments, particularly in cases where the defamatory matter has spread widely or the original poster is uncooperative. New Section 36A provides courts with the power to issue orders requiring non-party digital intermediaries to take access prevention steps to prevent or limit access to defamatory content online. This includes intermediaries who are not directly involved in the defamation proceedings but facilitate access to the content. These orders can only be made if the plaintiff has obtained a judgment for defamation against the original defendant or a court has granted a temporary or final injunction preventing the defendant from publishing or republishing the defamatory matter. The court must provide the non-party digital intermediary an opportunity to be heard about the appropriateness of the order. This allows intermediaries to present arguments about their capacity to comply and the feasibility of the requests actioned. In urgent cases where immediate action is required to prevent further harm, the court can issue temporary orders without first providing the non-party digital intermediary the opportunity to be heard. This exception ensures that urgent situations can be addressed promptly. The new provision applies to all digital intermediaries, including those eligible for statutory exemptions from defamation liability. This ensures that even intermediaries who are not legally liable for the defamatory content can be ordered to assist in preventing further dissemination of the matter. This reform aims to address the challenges associated with online defamation, particularly in the digital age, where content can spread rapidly and where original posters may be difficult to hold accountable. By empowering courts to issue orders against non-party digital intermediaries, the bill seeks to improve the effectiveness of defamation remedies and provide a more comprehensive approach to dealing with the online defamatory content. Madam Speaker, the proposed bill also introduces several minor amendments to refine the operation of the existing provisions in the Defamation Act 2006. These changes aim to clarify legal concepts and ensure that the law functions as intended. Section 8 excludes corporations from suing for defamation, except for certain small or not-for-profit organisations. However, the definition of employee previously did not include independent contractors or other heavily involved in daily operations. The bill updates the definition of employee to include individuals engaged in the day-to-day operations of a corporation, regardless of their formal employment status. This change prevents larger corporations from circumventing the prohibition on defamation claims by structuring their workforce with independent contractors. Section 8 is further amended in relation to whether a corporation is related to another, as based on Section 50 of the Commonwealth Corporations Act 2001, and which can be overly restrictive. The bill replaces the term related to another corporation with associated entity, aligning it with definitions used in Section 50 AAA of the Corporations Act. This broader definition better reflects the relationships between entities in modern business structures. A number of procedural aspects have also been amended, including broadening the criteria for determining if a corporation is small enough to qualify as an excluded corporation for defamation claims. allowing the court to determine costs if a defamation case ends due to the death of a party, addressing a gap in the current law and ensuring fairness and clarity, and modernising the provisions for the giving of notices and other documents such as using email, messaging or other electronic communication indicated by the recipient to better align with contemporary communication practices. The amendments in the bill are designed to refine and clarify the operation of existing provisions in the Defamation Act 2006 by addressing technical issues, updating definitions and streamlining procedural rules. The bill seeks to ensure that the Act functions as intended, providing a balanced approach to defamation claims while adapting to contemporary legal and digital environments. Madam Speaker, this is an important bill. It implements the nationally agreed model defamation amendments and fulfils the Northern Territory's commitments. This bill modernises the Defamation Act 2006 and ensures continued uniformity with defamation legislation around Australia. I'm pleased to commend the bill to honourable members.
The question is that the bill be read a first time. Those of that opinion say aye. To the contrary, no. I think the ayes have it. The clerk.
A bill for an act to amend the Defamation Act 2006, the Limitation Act 1981 and the Local Court Criminal Procedure Act 1928.
Minister.
Madam Speaker, I move that the bill be referred to the Legislative Scrutiny Committee for a report by the 12th of March 2025.
Question is that the motion be agreed to. Those of that opinion say aye. To the contrary, no. I think the ayes have it.